Hello, my name's Michael Robinson. I'm a director at Emerson Solicitors Limited. We're based in Sunderland and in Newcastle upon Tyne. I've been a solicitor for 30 years and I've been involved with various areas of law over that time, but in the last 20, 25 years, I've dealt with crime and prison law matters. What I really want to talk about today is a subject which gets a lot of publicity, violence against women and girls, and just a few of my comments upon some of the things that have been proposed, some of the things that have been said, mostly about the court process and how I think it in fact can be improved and why I think that what is being done won't improve it. Violence against any person is appalling. Violence against a partner by a man is absolutely appalling. Violence against girls by their father or stepfather or boyfriend or work colleague is appalling. There's absolutely no doubt about that. Violence against anybody is appalling. Men are more likely to be the victim of violence by men than women. Men are more likely to be killed by men than women. In other words, men as the victims of the offence. Men are more likely to commit suicide. Men are more likely to be put in prison as a result of any offending that they commit than a woman. So there are aspects to this whole debate which sometimes rely upon assumptions and a form of prejudice rather than informed debate. So let's proceed on the basis that all violence against anybody is wrong. What we need is a police service that is fully equipped, resourced to be able to deal with the amount of violence that there is in society. So that if somebody complains about, for instance, they're being harassed, they're being followed, they're being subjected to online abuse, that there are enough police officers with enough skills and with enough resources to be able to deal with that quickly. In other words, investigate what's been said and speak to whichever person it is suggested is the perpetrator of those offences, whatever their gender. Then we need there to be enough police officers to be able to review the evidence and to discuss the matter with the Crown Prosecution Service. And we need enough prosecutors to be able to prosecute people who have enough experience and understanding of the law. And then we need enough courtrooms with enough judges in them, or enough courtrooms with enough magistrates in them to be able to deal with the amount of cases that will be brought to court. Because it's only right that somebody's case, whether they are the victim of violence, be that the spoken word or the physical act, or be they the perpetrator of that violence, that their case is heard quickly. So it's still fresh in the mind of the victim and the perpetrator is able to be dealt with swiftly, be that so that he or she is convicted and punished, or he or she is acquitted and released, and their character unblemished by that event, in any event. So those, I would suggest here, are the main things that need to be looked at, because frankly, there aren't enough police officers, there aren't enough prosecutors, there aren't enough courtrooms with judges sitting in them in the Crown Court to deal with the more serious matters. It is a slow, ponderous process which does not deliver justice timeously. It delivers a form of justice slowly. And of course, there are so many cases that are sifted at the start. All types of violence involving all types of people. So really there needs to be a dramatic change in the approach of the state to the justice system. Now, there are improvements that could be made in the justice system itself. For instance, there's been an attempt by Her Majesty's courts and tribunal service to introduce common platform. It is in essence a pointless, ponderous, slow computer system which does little to speed up the process, primarily because the court's legal advisor has to put in all the information in the courtroom, thus meaning that court cases have to sit and wait whilst that is done, and that can be 15 or 20 minutes even of dead time. What would make sense is if there was an administrator in the court with the court legal advisor, who was the person who was doing all the resulting, typing up, sending emails, whatever it is that needed to be done there, then live in court, because then the court legal advisor and the magistrates or the district judge or deputy district judge would be able to become involved in that process to make sure that it was accurate. So I've got nothing at all, there's nothing at all wrong with real-time updating and resulting. It's just they've got the wrong people doing it. But in the back office, there needs to be more people, because if one rings up and asks for information or sends in an email asking for information, this applies to HMCTS as well as the Crown Prosecution Service as well as the police, often there's no response, or often the response is delayed because there's so few people working in the admin side of things. Justice is a people service. It involves people. There are too many people who have made money out of talking about the fact that if the system was digitalized and computerized and AI was introduced and all sorts of things, that it would make it a lot simpler. It doesn't work in reality. And it's the view of justice that those that make these decisions have, which is the problem. They don't see it as a local service delivered by local people to local citizens. They see it as something that can be just done, like you're complaining about an item that's been received from Amazon and you go through their reconciliation process. They are not the same thing. I'm not saying that all cases are serious. Clearly there are some to do with minor fines for parking infringements and whatever that just aren't that serious. And yes, streamlined systems for them work, but where someone's been arrested or where someone wants somebody to be arrested, it doesn't matter what the offence is. It's a serious matter because liberty is at risk in most criminal cases. There are very few where custody is not a possible sentence. And so I want a change in attitude from politicians to the justice system so that it works. It works for everybody. It works for the complainant. It works for the defendant. Oh, and it works for the suspect, so someone that's interviewed and not even charged. Now, in relation to some serious matters, there have been some changes introduced. Long ago, it was introduced that a vulnerable witness would not have to give evidence actually in court. They could give evidence via live stream, or they could give evidence behind screens. More and more, that evidence is given on a pre-recorded video, and they're followed up by sitting in a room out of the court. But also now, cross-examination of vulnerable witnesses is done before the trial takes place and is pre-recorded. And there are people, apparently they are experts, who are able to suggest what sort of questions could and should be asked. It's a farce. It does not address the issue because juries like to see people in court so they can see their face. They can feel what they are like. They can see what they are like. The only person who's in court is the defendant. And it's no wonder that these so-called improvements to the evidence giving a process really haven't made much difference at all. In fact, they've probably made it worse for victims of crime and a lot easier for those who defend and for the defendant. And that's something that really needs to be considered. There really needs to be proper research undertaken. Now, one of the big criticisms, especially in rape and sexual offences cases, is that the woman is put through it all again by the nature of the questioning of her by the defendant's advocate. How else is a defendant, if they have given a version of events in their police interview or they've given a version of events in their defence statement, how else is the victim supposed to be able to comment upon what the defendant says if they're not asked about it? And it may be upsetting for that to be put to them as if it's the truth, but it is the defendant's truth because the defendant has said it. And therefore, if there is to be a balanced trial, it is only right, only proper that that evidence is put to the victim so that they can respond to it. I have no doubt that sometimes, maybe often, it's upsetting and painful, but that has to be the way of it, because otherwise all we'll need is a situation where a victim says, this person did this, and the state says, well, if that person says you did it, you must have done it, so we'll lock you up. How else are you supposed to challenge it if you're the defendant? How else? And juries, despite what a lot of people say about them, aren't stupid. What they understand is that if they are to convict somebody, they must be satisfied so they are sure that that person has committed the offence that is alleged against them. Sure that that person has committed the offence. Often referred to as proven beyond all reasonable doubt. But what it means is sure. So if they think they might have done it, they've got to acquit. If they think they could have done it, they've got to acquit. If they think it's more likely than not that they did it, they've got to acquit. Because they've got to be sure. It's only right. Because if it was you and you were falsely accused, you'd want the jury to consider the evidence and you'd want your case put. The assumption that all the allegations that are made are true is the problem here. What the assumption ought to be is that the defendant ought to be allowed to present his defence in the way that he and his legal advisors feel is best. There's no point ripping into a witness if you're acting for a defendant. Juries and judges don't like it. The judge won't allow it. It'll only make the case for the defendant worse. But you can ask the questions that need to be asked. And yes, the victim may feel upset by it, but it's important that those questions are asked for that reason. I think too much emphasis, I'll probably get criticised for this, is placed upon the rights of the victim in a criminal case. My experience, my belief, is that the rights of the defendant should be the priority, because we could all be a defendant. That doesn't mean that the victim cannot get support. That doesn't mean that the victim cannot get help. That doesn't mean that the victim cannot have explained to them precisely what is going on, why it's going on, what the process is, what the defendant says. There's lots of stuff that can be done better in the background before a trial date. The way the case is prepared, the way the case is served, the way that the case is organised can all be done a lot better, and would probably save the victim or the complainant a lot of anguish. And that takes me back to the point, more people investigating, more people preparing, more people considering on behalf of the Crown will make the situation for the victims, the complainants, better. That's the way to do it. That's the way that will make a real difference. Anything else, quite frankly, won't make any difference at all. Michael Robinson, Emerson Solicitors, Sunderland and Newcastle.